Yeah.
Isn't it that we always want to understand what are the principles for a fair trial? And once you have a eminent speaker like Dr. A. Vijayalkashmi, who is teaching in the School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University, Chennai, there couldn't be a better enlightenment, and that too on a Saturday. Even though she had an appointment with the doctor, but her passion to pay back to the society made her change the schedule, and here she is with us to share the knowledge sharing with us. Over to you, ma'am, and thank you for accepting our invite.
Thank you so much, sir. It's always my pleasure and privilege to be part of Vikas sir's program and platform. And as said by sir, though I am having some health issues, but always been academics and relating to the academic discussion, we should come across all the ailment. And though it is an online, it will be so comfort for me to in that. And I'm so sorry, sir, because I preponed the session from 6 o'clock to 5 o'clock due to some other appointment. Thank you so much. And good evening to all those who present today through this virtual platform. And I think most of us from either from Tamil Nadu and other state are being facing a lot of notifications regarding this CJ exams or judicial magistrates exam and other thing. So most of the people are being in the presentation or preparation of these exams. And I hope that this class to some extent will cater your needs, and to some extent it will be helpful for you for the preparation of it may be the academic exams or for this judiciary exams or for the competitive exams. So as said by sir, today we are going to discuss about this principles of fair trial. So this is what we are going to discuss today. So whether my screen is available, visible to everyone?
Yes, ma'am.
Thank you, sir. So this with respect to this principles of fair trial, because trial is the process, because already usually we had some confusion regarding three terms. One is investigation, inquiry, and trial. Sometimes we interchangeably use the term inquiry when we have to use the term investigation, and sometimes we use the term investigation where we have to use the term inquiry or inquiry. But these three terms are not synonyms, which cannot be used synonymously or it cannot be used interchangeably. So investigation is a process which is purely meant for collection of evidence, and this should be only handled by the investigating officer, that is the police. We all know that it comes under section 154 to 176 of the CRPC, which speaks about the investigation process. So it has 5 steps: collection of evidence, recording of statements, collection of material documents, arrest, preparation of final report, and everything. But this investigation report or the final report, which has been filed by the investigating officer after the end of the investigation under section 173 of CRPC, is going to play a role in the second category or the second phase of a criminal case, that is the during the course of trial. So we are all know that criminal justice system, either it may be the Indian criminal justice system or it may be the international criminal justice system, the principle of natural justice somehow had an interplay with the principle of fair trial or fair trial principles. Not all natural justice principle will equally applicable in the fair trial principles, but fair trial principles are the inclusive part of this natural justice principle. So trial, then what is a trial? What do you mean by this trial? So trial is nothing but a judicial proceedings about determination of guilt or innocence of a person. So it's a judicial interpretation, and this interpretation or determination is for either guilt or innocence of the person. So we all know very well that usually, or a general principle or a golden principle of Indian criminal justice system is presumption of innocence. So a person who has been produced before the court or who is standing before a court shall be presumed to be innocent beyond until the state has proved the case beyond all reasonable doubt. So they are being giving the entire burden of proving the case on the state or the prosecution side. So the accused is being presumed to be innocent. In such a case, there are some principles that has to be adhered or to be followed throughout the trial procedure. It may be the warrant trial procedure or summons trial procedure or a summary trial procedure, or it may be the procedure relating to any other special laws. Either it may be the penal law or any other special or supplementary law relating to criminal justice system. So this fair trial protects the three aspects of the accused. One is human rights, fundamental rights, and third one is the rights guaranteed under the CRPC. So these three rights are being either fulfilled or being safeguarded or guaranteed by way of proper invoking of this fair trial principle. So here you could see the two contradictory. One is trial, another one is fair trial. So what is the how we can differentiate between the trial and the fair trial? So trial means it be in a process where you can go according to the law, what it says, black and white, what the law says in the book or what the law says in the CRPC. But fair trial speaks about the procedures to be followed, or it becomes an obligation of both the judiciary and the organs of the judiciary, like the prosecution office, the investigating office, even the defense counsel, to be followed till the conclusion of that trial. So we are having 9 to 10 or 11 fair trial principles to be followed, and let us discuss about this fair trial principles in this particular session. So the foremost principles of the fair trial is that separation of power will come the second. The first one would be the adversary system of criminal law. So we are following the Indian criminal justice system is following the adversary system of criminal law. We all know very well that there are two types of criminal justice system. One is adversary system of criminal law. Another one is inquisitorial system of criminal law. So countries like common law countries or English country are following the inquisitorial system, and we are following the adversary system of criminal law. So what is this adversary system of criminal law? So adversary system of criminal law is the process where we are following as the presumption of innocence, which means the burden of proof is on the state. So because the state only converting a person into an accused. So till the completion of the trial or till the completion of the trial or till the case has been proved beyond all reasonable doubt, the person should not be termed or should not be called as either criminal or offender or an convict person. So till the trial has been concluded, till the state proved the case beyond all reasonable doubt, the status given to the person who is standing before the court is accused. So he has been accused by the state. Accused alleging the person that he has committed so and so. So then the law put the burden on the state, the prosecution, to prove the case beyond all reasonable doubt. So the burden of proving the case is on the accused side. This is adversary system of criminal law. That is what we are following. So that is what the entire CRPC and the Indian Evidence Act supporting the accused. So you could see in the Indian Evidence Act in a particular chapter, in this presumption, you could see the burden of proof or onus of proof from section 101 to 111 or even till 114A also, which includes the shall and may presumption, may presume. So it says that who is having the burden of proving the case. It may be the civil or it may be the criminal. The burden of proving the case is on the person who is instituting the case. In the nature of civil, you could see that the petitioner or the person who is expecting the remedy from the court. And in case of criminal law or criminal justice system, it is on the police or it is on the state or the prosecution to prove the case. So what do you mean by proving the case? So proving the case is establishing the prima facie or establishing the elements of the charges made out against the person in the charge sheet. So each and every charge has to be established or to be properly proved by the state. So the proving of the elements of the crime is the adversary system. It is by the state. So for example, if a person has been charged for the offense of we can take an example of murder, section 300. So it is the duty or it is the obligation of the state, according to the adversary system of criminal law, to justify or to establish the elements of murder under section 300, which means by what act the death has been happened, the nature of injury, and the consequence of death, whether it has a direct link between the injury and the death, whether the accused is having the high degree of knowledge or intention for committing the crime, whether the injury caused is the direct cause of death. So these are all the elements of section 300. This has to be proved by the state. This is adversary system of criminal law. If it is an inquisitorial system of criminal law, the burden will be shifted to the defense, which means the accused side. So the accused has to come and prove his innocence. There is always a difference between proving guilty and proving innocence. So proving guilty is establishing the prima facie. Proving innocence is that you have to establish your innocence by establishing that somebody would have committed, not by the person who has been standing before the court. So the adversary system of criminal law is evading out or washing out this burden on the accused, and we are following this adversary system of criminal law where the entire burden is on the state only to prove. But in limited circumstances, in limited situation, this burden of proof shift from the state to the accused side. And we are all know very well the burden of proof according to Indian evidence that when a person avails or the moment he wants to apply any exemption, it may be the general exception or it may be the private exception or private defense. So from section 75 to 106, if any one of the exception, if the person wants to avail in his case, that is the moment the burden of proving the situation shift from the state to the accused to prove his defense. Other than that, the entire burden of proving the case is on the accused. This is adversary system of criminal law. But in some special cases, in some special supplementary laws or a special law like POCSO, Protection of Children from Sexual Offences Act, the onus of proof is on the accused. So if a child make any complaint about the sexual assault or aggravated sexual offense committed by any person, sometimes it may be in an aggravated form, which means the person who committed the offense against a child comes within any authoritative position. It gives more and more stronger obligation or the burden on the accused to prove the case that he haven't committed the offense with an intention of that. And a second example for shifting of burden of proof is NDPS Act. If I am in the possession of narcotic, drug or psychotropic substances with the proper license or authority or permission, or if I am in transporting, or if I'm caught hold while consuming. So there the culpable mental state is that the court shall presume that the act has been committed with the intention unless the contrary is proved. So the interpretation of the phrase unless the contrary is proved is nothing but shifting of burden of proof from state to the accused. So only with like these principles, like these areas, limitedly the burden of proof has been shifted from the accused state to the accused. Other than that, the foremost thing is that the state is responsible to prove the case beyond all reasonable doubt, either proving innocence or proving guilty of the person. So this is the first principle. The second principle about this fair trial is that independent, competent and impartial judiciary. So what is this independent, competent and impartial judiciary? So we can you can otherwise call it as separation of powers for independent judiciary. So according to the constitution, we are having three wing: executive, legislature and judiciary. So if you want to commit a case, if you want to conduct a trial, the judiciary should be given a full and fair freedom to conduct the trial without the intervention of either the legislature or the executive. So separation of judiciary from the legislature and executive will give the power and scope to the judiciary to conduct the trial without any interference and with a free mind and impartiality. So the independent functioning of judiciary without any intervention or without having any influence or force or pressure into it. So it gives more and more interpretation. That was Article 15 of the Constitution says that there must not be any intervention between this. And the second, regarding to this independent judiciary, with some limited exception, the higher judiciary should not interfere with the lower judiciary. So the lower judiciary, which means the magistrate court, is having their own jurisdiction, powers and functions, and the higher judiciary is also having their own jurisdiction, powers and functions. With the limited thing, the higher judiciary should involve within the functions of the lower judiciary. So the higher judiciary must be the a monitoring capacity in such a capacity, should observe, should supervise whether the due process of law or the fair justice has been awarded. Instead of that, they should not interfere or they should not intervene within the powers and functions of the lower judiciary. Involvement or the intercession of this executive or legislative to the judiciary during the course of trial. So what I am discussing about here regarding the separation of powers or independent judiciary is that only limited to the during the course of trial. So when there are some cases where you cannot any government order or anything may interfere into this trial procedure unless otherwise it comes from the judiciary, not from the executive or from the judiciary or from the legislature. So in such a case, each and every judicial hierarchy with respect to this criminal justice system, from the lowermost, for example, judicial magistrate, chief judicial magistrate, assistant session judge, then high court. So chief judicial magistrate will come under the control of CJM or chief judicial magistrate. This CJM and JM will be being monitored by the sessions court. This sessions court, CJM magistrate court will be monitored by the high court. So this is the hierarchy it comes to judiciary. There may be the interlink and there may be the passing of orders between these judiciary, but not by the external powers which cause any disturbance or any abuse between the proceedings of the trial. So again and again stressing, regarding the trial principle, there must be the independency of judiciary in conducting the trial. So that's what we are coming. You could come across varied interim orders. If I want to get an injunction to stop the proceedings further, that should be done only by the judiciary, not by the legislature or not by the executive. If I want to get any remedy in between return of property in case of any trial is going on and my vehicle has been seized as because my vehicle has been misused or abused by my friend for the commission of the crime, and I want to get back my vehicle, I will approach only the judiciary, not the executive or not the legislature. So in such a case, there must be the interplay or there must be the interaction between the higher judiciary and lower judiciary, but not the involvement of this executive or legislature. And the second thing, independent judiciary, is that any order passed by the lower judiciary, unless otherwise it involves possible ratification or rectification of error, the order shall not be modified, or it shall be modified when there is only the question of law, which already we speak about this, appeal or revision or review or other things. So other than that, the orders shall not be. And we came across various judgment, and we are all very the very interpretative judgment passed 2 years back, I think 3 years back, on this POXO Act, where a judgment passed by the High Court of one of the state, where it has been questioned by the Attorney General of India as a to the Supreme Court, where the Supreme Court in turn changed or reversed the judgment passed by the High Court, where the original judgment has been retained by the Supreme Court. In such a case, only there will be a modification of orders. Otherwise, then the legislature shall not pass any order with respect to trial, and the executive should not pass any government order or any interim relating to this judicial process. And with respect to the second one regarding this impartial judiciary. So impartial judiciary speaks about the powers or functions within the judiciary. So impartial judiciary, we are all very well about the maxim, nemo judex causa improperio actio, which means no person shall be the judge of his own case. I shall not be the judge of my own case. So this is impartial judiciary. So last week also, one of the judge in the Supreme Court has rescued himself from the case as because he was one of the advisor when he was an advocate. So this shows the impartiality in the judiciary. If I'm having any personal interest in a particular case, and if there is a possibility of showing any injustice or partiality towards the case, I should rescue from the case by myself. So I should not involve in that case. That is impartiality. So another thing, either the witness should not be interested witness, either the party should not be the interested party, either the case should not be the interested cases. So in any of these matters, or sometimes some judges who are very particular about this impartial judges, if any judgment passed by them and there was a lower judiciary, and if the case come before him when he was elected as any higher court judiciary, he will not take the case as because there may be a possibility of partiality that was judgment passed by me. How could I myself will change my own judgment? So in such a case, there are some judges where they are showing that as this judgment passed by me, I should not. That's what the judgment passed by the judge shall not be placed before the same judge in way of appeal or revision. It should be go before some other judge. Very limited in cases like a second bail or third bail only. They gave the judgments that the second bail application or third bail application should be placed before the judge who dismissed the earlier one. So that's what we are filing the appeal before the division bench if any single bench has passed the judgment. So this is the impartiality. And the third one is competent judges. So what is this competent judges? So this was, I told you, the hierarchy. The section 6 to 21 of the CRPC speaks about the classes of criminal court under the CRPC, from JM of first class, JM of second class, CJM or CMM, principal additional sessions court, then principal sessions court. So this is the 4 classification, and in between we come across this executive magistrate or sometimes special judicial magistrate. But this is the 4 or the basic classification of courts. Each and every court has its own jurisdiction. So though JM of second class or MM of second class is still in the CRPC in a black and white, but practically we are not practicing JM of second class. We are having only the judicial magistrate or metropolitan magistrate. So the powers of judicial JM or MM is 3 years of imprisonment and fine of rupees 10,000. So this was the jurisdiction of the magistrate court. So in such a case, a magistrate shall not eligible to conduct trial of a case which is punishable more than 3 years. If there is a series of charges, for example, in a single case, a final report has been filed, a charge sheet has been filed, and in the charge sheet, it has 3 charges, and one charge is punishable with 2 years, one charge is punishable with 3 years, and one charge is punishable with 7 years. So where one charge, even a single charge, comes with the punishment which has been prescribed by either the IPC or any special law, which goes beyond 3 years, but immediately the magistrate has to commit the case to the appropriate or competent court. He is not competent to conduct trial on that. This is competence of a competent judiciary. So if next one is from 3 years to 7 years, it should be before the Chief Judicial Magistrate or CMM. From 7 years to 10 years, it is additional sessions or assistant sessions. More than 10 years before the sessions court, from 10 years to death sentence. And with respect to this death sentence, according to the procedure laid down by the law, it has to be referred to the High Court through this referred trial RT cases for the confirmation of this death sentence. So this is competent judiciary. So the competent judiciary is that if I'm being a chief judicial magistrate, if any trial or if any final report comes to me, which is punishable more than 7 years, I should not handle the case. I have to commit the case to the concerned or competent judiciary. I cannot come and justify that even 2 charges are punishable only below 3 years. No. If any one charge crosses this 3 years or 7 years, it should go before the competent judiciary. So this is competent judiciary. So the second principle is impartial, competent, and independent judiciary. So the first one is adversary system, and the second one is competent, impartial, and separation of powers. And the third one is the transparency regarding the proceedings, or we can call it as courts must be open. So everyone must know what is happening. Everyone must know about the proceedings of the case. That's what usually a general practice, that courts must be open. Anybody can go and witness the case, or anybody can go and see what is the status of the proceedings, provided some cases where it is being prescribed that it should be conducted only in camera proceedings. So for example, cases like a sexual assault, or cases against children, or cases relating to integrity of any person. So then other than those cases, other cases should be conducted in an open court. Court must be open. So what is the interpretation of this category, that court must be open? So what is this thing you can say that the court must be open? The court must be open in such a case, what it says that must be the open proceedings. Any proceeding should be in the open court, which means both the parties should present, and any orders that can be passed should be in open. That's what you could see on the date of judgment as per the CRPC, both the parties should present, and the presiding officer will read over the operative portion of the judgment. So it is there in the CRPC. I think most of you would have come across this procedure in the trial court. You could see the judge will read the operative portion of the judgment. It may be the magistrate or it may be the sessions. So the operative portion is whether the person is found guilty or not on each and every charge. So whether the person has been convicted or not. If it is convicted, what is the sentence? What is the term of sentence? And if any fine has been imposed. So this has to be openly read out and openly informed, that everyone should be given, and that it should be an open message to everyone that the case has been tried in front of everyone, taking evidence or arguments or cross-examination. That's what some of the seniors would encourage the juniors. If any particular trial is going on, they will send the juniors to the particular court. You go and observe that today the trial is going on. Today they're going to take the chief examination. Today there is a cross-examination by the senior counsel. My senior used to send me to a particular case. You go and observe. Today the senior counsel has come to Madras High Court, and they are going to argue on these cases. So it gives an independency and the transparency of the court, which gives the fair hearing and the fair proceedings about the case and the objectivity of this thing. And the section 327 of the CRPC speaks about the venue of the trial. So venue of the trial is not fall within this principle of fair trial, but in the venue of the trial, somehow it speaks about the to get the proper justice. So it may be in the common features of trial, but we cannot come within this fair principles of trial. So usually the venue of trial would be the place where the offense has been happened. Sometimes they will argue that the accused is not possible to come to the court, or the victim is facing some threat if he comes to the particular court. That is the exception where they will change the venue of trial. Other than that, they will not change the venue of trial. And the most important thing with respect to the principal, this competency is that regarding passing of sometimes with respect to this bail jurisdiction, there may be the contradiction, or there may be that some people will overcome the principles of this competency. For example, if it is an offense punishable with death sentence, we all know very well that according to the investigating process, till the completion of investigation, till the filing of final report, the case will be rested before the magistrate court only. And according to 167, if the investigation not completed within 24 hours, and subclause 2 gives an mandatory bail provision. So sometimes what the advocates, or sometimes what the counsels will do will directly file a bail application before the High Court. For example, if the case being an 302 for murder case. So that time, if suppose I am being an advocate who is presenting my bail application before the High Court for an offense of section 302, by stating that he was he was in the prison as a remand prisoner, still the investigation is going on, the final report has not yet filed, so expecting a bail from the concerned court. So that time, the High Court will refer the bail application to the magistrate court according to section 167 subclass 2. Though the magistrate is not empowered to enlarge or to proceed with the bail application where the offense is punishable more than 3 years, but these provisions, these reservations, and these concessions gives me to go or to extend the boundaries of competency of court. So this is simply an example where I can approach the magistrate court even the offense is punishable more than 3 years according to section 167, provided when investigation is still going on and no bail application is filed, then the bail would be the mandatory if the investigation is continuing for more than 90 days. So these are all the aspects, and these are all the procedures which comes within this competence. And the next one is about independent. On the next one is about the represented through proper person or right to defend himself according to section 302. I think everyone very well knows very well about it. So this was the one of the natural justice principle and as well as fair trial principle. So no one should go unheard. Principle of R.D. Altram pattern. So they should hear both the side. So as because my case has been committed from the magistrate court to the sessions court. For example, my case is a 302. And till the committal proceedings, my client haven't appointed any advocate, or the advocate appointed is only meant for the lower court, not for the sessions court. So once the case has been committed to the court of session, on the date of opening of the case, the court should ask, do you have your advocate on your own, or you are expecting this court to appoint an advocate? So this is, every person should have right to defend himself through a competent person. So this competent person, according to criminal justice system, is a defense counsel. Already defense counsel is coming under whom? This function of the judiciary, CRPC. The CRPCs have 5 main functionary. One is police, prosecutor, defense counsel, criminal courts, and correctional institution. So under this, defense counsel is also part and parcel of the CRPC, and this is defense counsel is a person who is a competent person to defend the case on behalf of the accused. So when a person who is not in a position to assist to appoint an advocate on his own, then the court on its own, the court should appoint a person through free legal aid. So continue towards this to defend the case by a competent person is this free legal aid. It's an interlinked, it's an go one hand in hand, where the person who is an indigenous or a person not in a position to appoint a private advocate, then he has to present his request before the court. For as I told you, when the judge asks the accused, do you have an advocate on your own, or if you want the court to appoint anyone. So suppose if the person says, no, I am not that much of rich enough to appoint a person on my own, will you please appoint an advocate from the legal aid? So this is the thing which satisfies section 302 of the CRPC, where defending a case through proper defense counsel or competent person. And this has been enshrined in the constitution also. So this fair trial, this particular point is satisfying natural justice, human rights and fundamental rights. So it's one of the aspect of human rights also. In the UDHR, it says that everyone should be heard properly. So everyone should have the right to present or submit his own case. So in such a case, this defending through a competent advocate is inclusive of free legal aid also. So this free legal aid, where it under Article 39A of the Constitution, which gives you the right to get a free legal aid service from at the cost of the state. So defending. So what is the role of the defense? What the defense advocate will do during the course of a trial? So the defense advocate will simply defend the case. What do you mean by defend the case? So what the defense will do? He will simply refuse the allegation. That is the defense. So it is not his duty to go and search the actual person who committed the crime. So his duty is to break all the allegation placed by the state against the accused by way of breaking such an allegation, creating a doubt in the minds of the court, and try to get the benefit of doubt to the accused and get the acquittal for the accused. So defending a case or a defense advocate must be a competent person to defend his case, and he should have the ethics to present himself in a proper manner to defend the case. So defend the case is that only to break the allegation by way of creating. That's what we used to say, cross-examination is an art. Chief examination is not an art. Chief examination is only the reciprocal or repetition of 161 statement, 161 subclass 3 statement, but cross-examination is an art. So this cross-examination only going to break the allegation or going to create the doubt in the minds of the court, where the doubt is so strong, when the doubt is so voluminous, then the benefit will be given to the accused person and the accused will do. And the second part of this to be defended through a competent advocate, which includes to assess the public prosecutor also. So, where though I'm victim, so already I think I have, I don't know whether I have talked about this in this platform, the concept of victims or the placement of victim in the criminal trial. So when we are talking about the fair trial principle, we are entirely talking about only the accused, but very limitedly we can talk about the victim. So in this fair trial principle involves the rights of the victim also. So the competent advocate for the victim is the state, it is the prosecution. In spite of that, if I want to appoint any person to assess the prosecution, that is also permitted by the CRPC. So where I am in a position, or if I want to appoint, or if I want to submit a petition before the court where the trial is going on, requesting the court to permit the person to assess the prosecutor by way of appointing an advocate under section 301 of the CRPC. So, and the third one is that the court must be in a position to be heard both the sides. So when I think some of you or most of you or maybe all of you become a judicial officer, when you're going and occupying the dais or sitting the court, please be like a blank paper, please be in open-minded, and don't go to the court with any predetermination or determined mental status that the person might be a person who has been committed the crime, or he might be then innocent. So the arguments and the evidence and the witnesses only going to write the judgment, not our own perception. So that is the role of this thing, where the evidence or the witnesses should be taken in the presence of both the person, which means the accused and as well as the victim. And without the presence of either party, the trial should not be conducted, provided again if there is any excuse, dispense with the personal appearance of the accused or dispense with the appearance of the victim, the de facto complainant, the case can be conducted. Other than that, it should be conducted in the presence of both the party. So other than the prosecutor or the assisting the prosecutor or the defense counsel, no person shall be permitted to get into the trial procedure. So what is the possibility of another person may get into the trial procedure? So either the expert or the inspector or the investigating officer or any person from other than these three categories, prosecutor and the defense counsel, and the assisting prosecutor also comes within the prosecution itself. So other than that, no person should be comes within the trial procedure. And regarding this accused person, so accused person with respect to this, he may be sometimes maybe the person who is a normal status, and sometimes he may be the person of differently abled. So in case of differently abled person, as because he is not in a position to present his case in a proper manner, and in a blanketly you cannot appoint any advocate as a legal aid counsel, you should keep in mind the challenge it has been facing by the differently abled person, and such a competent and expert must be appointed as a person who is in a position to convey the trial matters to the accused or to the person who is standing in front of the court. So for example, so because after this rights of the person differently abled and as well as the UDHR, we are being prevented and banned from using the term like a deaf, dumb, blind and the thing. So we have to use a term like visually challenged or differently abled, hearing impaired or visually impaired, and intellectually challenged. So for example, a person who is being an having the speaking disability or hearing impaired, so you must have the person, when you're appointing the case, you have to appoint a person who is having the special educator towards that, who can convey the matters between the state and to the court to the concerned person. So this is also a thing which comes in the to defend the case by a proper and competent person. So competent person includes these type of interpretation, and not just like that you have to go and appoint a person to go and get the legal aid from that. So there are some cases where, more particularly in relating to this POXO cases, why again and again I'm giving example for the POXO cases is that which is more fragile and which is more sensitive, and the victim in the POXO cases sometimes are differently abled children. Due to their vulnerability and due to their status, they are being easily targeted by the perpetrators. So sometimes we used to get case study from the judges who has taken care of the cases. They will say that most of the time we used to face the this challenge is that when the victim being differently abled children, more particularly intellectually challenged children, or the children who is having this other possibility. So by the time we are expecting the court to give more and more training or the awareness or the special capability to handle the children. So these are all things comes within this to defend the case in a by competent person. And with respect to this legal aid, again there was an one misconception when legal aid will commence. When I'm having the right to defend my case with a competent person, what is the interpretation of the term to defend the case with a competent advocate? Whether it is only the trial, but the Supreme Court says the question of legal aid arises or initiated from the moment the person got arrested. So that's what immediately after arrest, the person being produced before the magistrate under section 53 and 54 of the CRPC. The magistrate should ascertain whether the fair justice or the natural justice has been, or the constitutional fundamental rights has been informed to the accused at the time of arrest. So the foremost question is that, have you informed about right to bail and right to free legal aid? So that is the moment where the right to free legal aid arises. So there was a case passed by a lot of cases like Kathri case or Husainara Khatun or this Husdak case. So that was the case where the Supreme Court says that the moment the person got arrested, that is the moment the execution of free legal aid will start. So we cannot state that the free legal aid is only for the trial. It is for the bail also, or sometimes it is for the appearance of the person also, protection, surrender of the person also. So in such a case, the free legal aid, and you can have take an example of this Ajmal Kasab case also. So in Ajmal Kasab case relating to this Bombay Taj attack, where everyone were being prevented, says no, but it is the principle of fair trial. Whoever the accused may be, he should not go unheard. So the court has appointed legal aid advocate to defend Ajmal Kasab. And even in Nirbaya's case, the Supreme Court, the court appointed legal aid counsel to appear on behalf of the five accused person. Though we all know very well that they have committed the offense brutally, though we all know very well that Ajmal Kasab has committed the offense brutally. So in sometimes some cases may be argued by the person by themselves, that is party in person. But if the person who asked for this how to say free legal aid, he should be in a position to give the to get the free legal aid. And the next one is free speedy trial. So what is this speedy trial? So as because the case has not been conducted or the case has not been concluded because of the investigation process, how long the person would be languish in prison? So who is responsible for at whose cause the person should be languish in prison? Again, I'm coming to the first point, presumption of innocence. Till the case has been proved beyond all reasonable doubt, the person should be presumed to be innocent. So when a court and a law and the judiciary perceive the person as innocent, as because either the judiciary or the investigating agency is delaying the process, why should the person should be languish in prison? So in the proceedings of these things, speedy trial comes into effect. I think we all know very well about Sheila Base case, again Maneka Gandhi's case, and Nandini Satpathi's case. A lot of cases are there regarding the speedy trial, and which includes other provisions also. So for the speedy trial, we are having the limitation of taking cognizance of the case, and the 160 subclass 2 again. 160 subclass 2 comes within the investigation stage, and section 414, I think so. I'm not clear. If I'm clear, limitation of taking cognizance, where what is the time period for taking cognizance of the case. So this is all the process which gives you the principle that speedy trial. But every time, even the higher judiciary, the apex judiciary express its concern, there is a long pending of cases, long pending of trial, long pending of under trial prisoners, long pending of remand prisoners also, which means the investigation is still going on. So in such a case, as because, excuse me, just 2 minutes.
Ma'am, you will have to unmute yourself.
Sorry. Yes.
Yeah.
So the speedy trial is also one of the major concern, not only the Indian perspective, internationally, speedy trial is one of the major concern which speaks about the because a person who is languishing in prison, in turn, it affects the principle of, or the concept of this personal liberty. So arrest is nothing but prevention of personal liberty by the established procedure of law, as because the law permit me to prevail or curtail or go beyond this violation of this personal liberty. I cannot take it as granted, simply keep on extending the investigating process by keeping a person inside the prison. It may be the bail application, or it may be the trial procedure. So, and as per the trial procedure, there are limitation. If the case is punishable with 1 year, then the case should be initiated from the date of arrest within 6 months. If it is more than 1 year, within 2 years, limitation is 1 year. If it is more than 2 years, within 3 years, it is 2 years. So the limitation is being prescribed by the code itself from the date of arrest, not from the date of filing of final report. So in such a case, it protects the fair trial. If you delay the another the panic or the another dangerous situation in delayed the proceedings or delay the trial is that the evading away of my memory. Suppose I am being one of the witness. If you are calling me to stand and come and witness after 3 years of a case, totally I would have blank about what happened on the day, what color of dress he wore on the day, what was his, what he actually communicated, or the terms uttered by him on the day of commission of the offense, what type of weapon he used to cause the injury. So evading of my memory is also one of the danger for this delaying the trial. And the third one is delayed trial or delayed justice is denied justice. Again, we are not very about this concept. So speedy trial is one of the concept where it comes in the fair trial. Again, it's satisfying the fundamental rights and as well as the natural justice principle and the human rights. And that's what now we are being gradually coming into the hybrid mode of judiciary, both online and offline. So hereafter, I think thanks to the lockdown, thanks to the COVID, for this particular aspect, that even if any casualty, anything happened, we not bother about when the court will open, when the justice will be delivered. So now we are being used to do this type of platform where the trial or any process should not be denied or delayed. So now everyone has used to do. So this is the thing, how we are contemporarily converting ourselves from this process to the next process. So this is the principle of a speedy trial. Then the next one is about transfer of cases. So transfer of cases is that it's one of the principle which gives the rights to both accused and as well as the complainant or the de facto complainant. Most of the time, we blanketly or blindfoldedly or stereotypically apply these principles only to the accused. But the concept or the chapter does not say in such a way. It says principles of fair trial. Trial is for both the accused as well as the victim. The victim is expecting the justice in the hands of the court. Accused is expecting to prove that he is innocent to come out of the clutches of law. So in case of this transfer of cases, it says transfer can be asked by the accused and as well as the victim or the de facto complainant. So the accused can ask for transfer of the case by presenting his case before the court by stating that he will not expect a proper justice, as because the court become biased, or the court is not competent to hear the case, or the court is not purposefully delaying the case. Again, violation of speedy trial principle. So I can file a petition to transfer the case from one JM court to another JM court, one MM court to another MM court, one CJM to another CJM, from one sessions to another session, from one high court to another high court. I think so far we have came across a lot of incidents and a lot of examples for this transfer of cases. There are two subs. One is if the victim or the de facto complainant feel not safe in the place where the case is being conducted. Second one, in the perspective, in the view of the accused, where the accused feels that he is not getting proper justice continuously, as in the court is being on one-sided, so the court is not ready to hear on his side, then I have to file a petition to transfer the case from one court to another case. So I have mentioned only some of the example, like Zahira case in Gujarat, Best Bakery burn case, and as well as Ambedkar case, which relates to the state of Tamil Nadu. And there are a lot of cases also where sometimes how the de facto complainant asks for the transfer of cases. Suppose the case is instituted against a person who is influential or who is in power, or the person who holds the executive mechanism, and if the de facto complainant felt that if the case would have been conducted on the same place, there is a possibility of influence of the accused, either to tamper the evidence or to coerce or threaten the witnesses, so he will not get proper justice. So if it is being justifiable, if it is being acceptable by the court. So if I want to transfer my case from one JM to another JM, I have to file the transfer petition to the sessions court. So if I want to transfer the case from one session to another session, I have to file a petition before the High Court to transfer the court pending before the sessions. And if I want to transfer the case pending before the one High Court, and I have to file the petition before the Supreme Court. So the next apex courts or the appropriate court to give orders to transfer the case from one case to another, one court to another court, or from one state to another state. For example, in Tamil Nadu, I could give an example. One sessions trial has been transferred from Chennai to Bangalore, and in another case, one case, murder case, has been transferred from Tamil Nadu to Pondicherry. So in such a case, the state, the de facto complainant also asked for this transfer. And this one regarding sorry. So I think I already covered this. Represented by the competent person. These are all the thing, private complaint. And this one, if it is in a case of a private complaint under section 200, the complainant or the accused is the for example, if it is been a check bounce case, usually in magistrate court, most of the case comes under section 138, related section either 406 or 405 or 420 IPC, and very rarely some other cases will come. So where in cases of such a nature, both the parties are private person, not the public prosecutor. So if I'm being the person who affected because of the check bounce or the default of payment of any amount, I will file the complaint against the person who defaulted the payment. So at the cases, the petitioner and the respondent are the private party. So there you cannot expect that representation of prosecution there. Both the counsels are the counsels for the same this one, which what it says, the petitioner and the respondent. And the venue of trial, I told you, from section 177 to 189, that is local jurisdiction, where the offense happened, that is the venue of trial. But the exception to the rule of section 177, and there are some exceptions like continuing offense, got injured in one place, treatment in another place, died in another place. So this is where you can choose any of the jurisdiction. And the third one is conspiracy in one place, committed in another place. And the next one is action in one place, consequence in another place. For example, kidnapping, abduction, it is a continuing offense. So in these cases, venue of trial cannot be fixed, there can be a hard and fast rule. So if the place which seems to be inconvenient or unsafe either to the accused or the de facto complainant, it can be changed with the permission of the court. And the presumption of innocence, and I already discussed with you. Rights of the accused person, this already comes within this thing. So again, there is always a confusion regarding rights. Rights of arrested person is something different. Rights of person facing trial is something different. So because rights of the arrested person falls or constrained only during the course of trial and trial procedure, but rights of the person who is facing trial is something where the person is eligible to enjoy the rights during the course of trial, because that is the crucial stage where he is facing, where he is expecting to get either acquittal or the this conviction. So the first and foremost thing is that the person should be known about the accusation. So how this will make it out? How the accused person will know about the accusation? So during the course of this committal proceedings, So, for example, it is a 302 case, and today the investigating officer submitting the final report through the assistant public prosecutor under section 173, and the magistrate is taking cognizance of the case into his hand under section 191 to 199. So, after the verification of the documents, when he comes to the conclusion he is not competent to try the case, then he should commit the case to the competent court. While committing the case to the competent court, he should serve the entire copy of the case document to the accused at free of cost. So here another interpretation come. What do you mean by this? Copies of the document, right from complaint till the last paper in the final report in the charge sheet. So what are all the documents collected by the investigating officer and submitted to the court as a charge sheet, the entire document should be given at free of cost to the accused person. And it is immaterial how many accused are there. Each and every accused is eligible to get the copies at free of cost. And the second one is, suppose I am not familiar with the language that is mentioned in the documents, what I can do. So, for example, if any person who has been charged in Tamil Nadu, who doesn't know Tamil or English to read or to speak or to write Tamil, but the documents are entirely in Tamil or in English. So the translation or the interpreter must be there to read over and explain the materials or the content of the documents in the particular subject, in the particular document. So section 200 to 220 speaks about the capital proceedings. So after this taking cognizance, going through the materials, 220 to 210. 200 to 210 speaks about his criminal proceedings, going through the material submitted before him, justifying the charges has been properly made out, and coming to the conclusion he is not competent to try the case, committing the case to the competent court by serving the copies at a free of cost. So through this, when I'm being presenting my accused to my client to the next competent court, I'll be ready with my submission, with my defense. So this is to make the defense to make his own defense and submission. And before opening of the case, so before getting the framing of charges, the charges should be read over and explained to the accused person, which comes in the trial procedure. So opening of the case, explaining the charges, discharge, framing of charge. When discharge is not there, framing of charge and explaining the charge to the accused. So it is a duty of the court to explain the charges and possible of the punishment that can be or that may be imposed if the case would have been proved against him. So this is the thing, explaining the charges or content to the accused person before getting into this taking of evidence, chief or a cross or whatever it may be. And then you can come to this pleading guilty, that is a secondary, but pleading guilty is not a mandatory thing. And if it is a warrant case, and if it is not a case of summons case before the magistrate court or summary proceedings, if it is a warrant cases, it should be, the charges should be framed in writing. So after explaining the charges to the accused, it should be read over and written, and should be make it as a writing form, and should be signed and sealed by the presiding, that is the sessions court before that. And as I told that the trial should be conducted in the presence of both the parties. So in the absence of either party, if any examination has happened, that is a possibility for vitiating, where I can ask for the vitiating trial, or I can challenge this in my appeal. So as because I'm losing my opportunity to cross, or to losing my opportunity for the effective cross examination. If I am not present on the date of chief examination, and I am not in a position to understand what he has actually presented through his deposition, I only got the paper, and I'm not sure whether this was the statement given by the accused during his chief examination. But if I would have been present, I would have been understand, and I could make my cross examination or effective cross examination in the during the course of this trial. And the next one is that this is be excused. This can be exempted from the what to say personal dispense with the appearance of the person. So the dispense with the appearance of the person by both de facto complainant and as well as the accused. So usually the dispense with shall not be permitted during the time of taking evidence and the date of pronouncing judgment. So on these 2 dates, the court shall not allow the dispense with appearance. But other than that, the court will normally dispense with the appearance of the accused person. And as I told you, the dispense shall not be happen at the time of taking evidence. And I told you about this interpretation. I must be informed to the language. So I told you about the reading over the content of the document. And this one is during the course of trial. Suppose I am a person who knows only Tamil. I doesn't know either Bihari or Maharashtra, what are the other language, Odisha or Punjabi, the thing. So if a person who is giving evidence in his own vernacular or his own mother tongue language, if I'm not in a position to understand the content, I should be appointed with the translator or the interpreter. So he must be the person who is bridging the gap between the victim or the witness and the evidence to the court. So he has to interpret and he has to convey the message to the court. And second thing is, if my client being a differently abled person, special educator should present in the court to convey the thing. So as I told you, this would be very pathetic, and if you witness any trial in POCSO court, particularly if the child being a differently abled child, definitely you will understand the concept of this interpreter and how the child is being giving his own version through the special educator. Sometimes the children will be more affectionated and more trustworthy toward the special educator than their parents. So we have come across such a case. And the accused must be given the right to cross-examine. The accused should not deny the right of cross-examination, because cross-examination, I told you, it's an art. Examination is not an art. Cross-examination is an art. That's what Indian Evidence Act has given a lot of instruction regarding the examination. No leading question, no impeachment of the character, don't bother about the previous character, no question that cause any damage to the integrity of the witness. So these protection, this is called witness protection. But in our criminal justice system, is lacking in this witness protection thing. I think the bill is pending before the parliament. We are expecting this witness protection unit or witness protection system to the Indian criminal justice system. But in turn, if you go and see in the international criminal justice system, they are following a very excellent and very remarkable phenomenal witness protection unit. And even in international criminal court and Rome statute is having a separate organ, separate authority by name called witness protection unit, where it is only working for the protection, safeguard, and the interest of the witnesses only. So if I don't want to view the accused person, steps will be taken. If I don't want to disclose myself, my identity will be disclosed. So this is, we are following these principles only with some limited cases like offenses against women and children and integrity. But this has to be followed uniformly everywhere, so that people will come out to give evidence against the case or evidence relating to the case. That is the only thing which bothers me, that what would happen to myself if I come and give an evidence before the court. So this cross-examination should not be denied, and the person should be given rights to cross-examine. Sometimes if it is a case of party in person, the person he himself cross-examine the witnesses by cross-examine by the defense counsel to the prosecution witness, and cross-examination by the prosecution to the defense witness. So it's an mutually interchangeable. And the protection of witness through the burden of proving the guilt is entirely on the prosecution. Yes, it has been told that, but accused need not to prove his innocence. That's what I'm telling. So the duty of the accused is to break the allegation by way of creating doubt, by way of disproving the allegation. So what is the disproving allegation? For example, alibi, or for example, medical evidence, or for example, contradiction in the 161 statement and in the deposition. So that's what we are following, substantive evidence and the corroborative evidence. So corroborative evidence sometimes will act as a substantive evidence when there is a substantive evidence. That's what the circumstantial evidence. So this cross-examination or the defense counsel, by doing so, has to corroborate and contradict the evidence by way of disproving the charges. And the person denial without any legal cause by the court to issue process, which nothing but calling any person. Suppose I'm filing a 91 CRPC petition or 311 CRPC petition. 91 CRPC petition is summoning certain documents, and 311 petition is recalling the witness or calling any witness or the thing. Suppose I am filing a petition under section 91 CRPC or 311 CRPC, because the ambit of section 91 CRPC and 311 CRPC is at any stage of the case before pronouncement of judgment. I can invoke section 91 and I can invoke section 311 at any stage of the case before pronouncement of judgment. And this should not be denied by the judiciary and should not be objected. Even if it is objected, it shall not be denied by the court. And if the case ended in maybe the conviction or acquittal, it must be with a proper reason. So that is what judgment. What do you mean by judgment? This is something different from civil jurisdiction. In civil jurisdiction, we are talking about order and degree. And as well as in criminal jurisdiction, we call it as judgment and sentence. So judgment is the finality of a case, finality of a criminal trial. Whether the person find guilty or not is judgment. If a person find guilty, it is judgment. What is the sentence? Conviction is a sentence. And what is the punishment? Imprisonment is a punishment. And how the punishment should be served? To sentence to imprisonment for a term of so and so. So these three are the technical terms or technical aspect comes within the judgment. Found guilty or not, conviction, sentence to undergo, and the fourth one is imprisonment. Either imprisonment or fine or condemned to death until hanged by neck until death. So whatever it may be, depending upon the thing. So each and every charge should be given proper reason, either for conviction or for acquittal. So at the end of the judgment, the operative portion of the judgment would read, for example, the trial is going on for section 326 and section 506 part 2 or section 307 also. So as the state has proved beyond all reasonable doubt against the accused A1 herein for the offense of voluntarily causing grievous with a deadly weapon, which is punishable with the of IPC, and he is convicted and sentenced to undergo the sentence of imprisonment. And for section 506 part 2, the state failed to prove the charge beyond all reasonable doubt for the offense of criminal intimidation punishable under section 506 part 2. The accused A1 herein is acquitted from the charge. And 307, the same thing. So whatever the charges has been written, whatever the charges has been framed, whatever the charges based on which the trial has been conducted, that that thing should be effected with a proper reason in the decision. So this is judgment. And no person should be punished twice, artifice acute or artifice convict. No to acquittal and no to convict. So either you can correlate this with this article 20 subclass 2 double jeopardy. No person shall be punished twice for the same cause of action. So this is the thing, same cause of action is the thing, not of some other thing. So if a person who has been already where he has been tried, convicted and sentenced to imprisonment, he shall not be charged again for the same cause of action. The charge may be the same, but not the cause of action. A person can be charged for 379 twice, thrice or 4 times, but not on the same cause of action. So that's what we could say, that this is artifice acute and artifice convict. So when this will affect? How this affected in the trial procedure? After the completion of prosecution witness, and if the prosecution witness failed to prove, still the doubt is there, that is the moment where the court can pass acquittal. But still the court need the particular aspect means then they'll go for this defense witness. After the completion of defense witness and after the completion of arguments, before going for passing judgment, the gap between completion, closing of argument and the date fixed for the judgment is this ascertaining about this artifice convict or artifice accused. Sorry, acute. So the person who has been already convicted for the same nature. For example, this is the third case coming against the same accused person for the same charge of 379 for different occasion, for different cause of action. Twice the court has convicted him with the lesser punishment of 2 years and 1 year. So this shows the habituality, and this time he shall be given with the maximum punishment. This will not affect the artifice convict or artifice accused. This is not artifice accused, it's an artifice convict. Already he has been convicted on the same cause of action. This cannot be happened. So, and this can be covered as Article 20 subclass 2 and Section 300 of the CRPC. And the subsequent trial in violation of the above, which means the suppose if it is not been given in the which has not been known to the court, or something has been suppressed by the accused or by the defense, or by suppressing that, and if you would have been filed the case without mentioning that, if it have been come to that, there is a possibility of expecting a compensation from the court also. And this one, I told you, the speedy trial, expeditious trial should be done at as early as possible, expeditiously as possible, and there shall not be any long gap between examination of witnesses. That is the very crucial stage where you have to think about, not on the argument stage or not on the before commencement stage. The crucial stage is taking examination of witnesses. It has to go immediately one and another, so that I am also keep in mind, the another person also keep in mind to keep meeting. And they have both in this expeditious trial is not a single-handed or a single person's, which means which is lies only on the prosecution side. No, it is it lies on both the sides. It is the obligation of defense counsel and as well as the prosecution to avoid unwanted adjournments, unwanted personal dispense with appearance of this case, and unwanted prolong the proceedings of the case. In some cases, for example, cases relating to this NDPS, obviously the case will be delayed because you cannot get the proper expert opinion from the forensic. You have to wait for the report from the forensic. Sometimes this may delay the process, but usually this should not happen. And more particularly, that's what in the POCSO and as well as another special court, it says that you should not go beyond more than 90 days or 1 year with respect to this trial. So which gives an justification regarding this trial. And if there is any delay in trial, you cannot call the trial as fair trial unless otherwise, if it is because of the prosecution. So if it is because of the defense, then the burden is on the defense to because why they have tried. And as I told you, Section 91 CRPC and Section 311 CRPC is a tool, is a weapon to delay the trial procedure. If I want to delay the trial procedure legally, I can file 91 CRPC petition, asked to summon certain document. If the document is allowed, the oppressed party will go for appeal before the High Court. If the High Court reverses the order, the another party will go before the Supreme Court. So till the completion of 91 CRPC petition finality, the original case will be pending before the lower court. Same thing for 311, recalling the witness. If it is permitted, appeal and revision. If it is not permitted, again appeal and revision. So these are all some of the aspects where you can proceed legally, but this should not be unless it is mandatory. And speedy trial, as I told you, Hussaina Khatun, Sheila Barse, and Shiv Kumar case. There are a lot of cases which speaks about this. And so these are all the thing where comes within this principles of fair trial. Other than these aspects, you can ask about this mandatory bail provision is also principle of fair trial, because there is a difference between remand prisoner and under trial prisoner. So remand prisoner is a person who is inside the prison without the completion of investigation, simply because of the delayed investigating process, he is languishing in prison. Under trial prisoner is because of the delayed process of the judiciary, he is languishing in prison. So sometimes under trial prisoners, remand prisoners, what they will do to close the doors of 116 subclass 2, to prevent the mandatory bail, what they will do, they will submit the preliminary final report before the court, which means under section 173 they will file the preliminary final report. Then they will come up with another petition under section 173 subclass 5 to go for further investigation. So 116 subclass 2 doesn't bother whether it is a preliminary report or final report. For it is 173. If 173 is CRPC has been filed, it will close the 116 subclass 2. So this is one aspect. And during the course of trial, as I told you, 91 CRPC and 311 CRPC are the tool and other thing where any person can go for, if you decide to go for the extension of delaying the proceedings. So whatever it may be, both the party, either party is expecting justice from the hands of the court, and both the party is rely or depending on the either party to complete the case. So in between, there are a lot of due to hastiness, due to for example the influence of the in outer pressure. So in the recent time, the judiciary facing the biggest challenge is media trial. If any sensitive thing happen, the first hand information comes from the media. Parallelly, media start to conduct their own investigation, publishing their own perspective, declaring their own result. So when actually after conducting the trial, if the court come to the conclusion and passing the judgment, we start to comment, criticize the judgment, because we already been trained and been inserted and been taught by these media that this is true. Whatever things come is not a true. So media trial is a biggest threat and challenge, and nowadays it is social media taking the law into his own course without having proper knowledge, without having a proper training, or without having interpreting the law. They are simply passing comments and making own judgmental opinion expression in the social media, which made us to believe that this has happened. If the court actually gives anything, we are not ready to. For best example is Nupul Talwar case. Even today, we doesn't know what happened, but we are being influenced by the media. It is an honor killing. The parents are the murderers. When the CBI court passes judgment that they are innocent, we are ready to accept it. And Monica Bedi's case, I can give a lot of cases. Even in Tamil Nadu also, I can give a lot of cases where the thing. So these are the threat for the fair trial. CRPC is there, law is there, justice system is there, justice administration is there. They are going according to the procedure. If you are facing any abuse of due process of law, you are having a strong hold of section 482 CRPC to question it. Inherent powers of the High Court, where you can question the possible abuse of due process of law to the concerned court. You can challenge it, but don't go according to the views and the whims and fancies of the thing, what is coming on the social media or the printed media. So apply, interpret a lot. I'll give one of the example when Justice Bhanumati Madam, when she was the session judge in Pudukkottai Sessions Court. I think most of you from Tamil Nadu heard about the John David murder case. When Madam Justice Bhanumati pronounced judgment of a double life imprisonment, some terms of imprisonment to run consecutively. Everyone start to criticize, how can this life sentence can be to run consecutively, where life means life. How can a person will run the sentence, a full life sentence, and whether he will come birth again and he will run the sentence twice? How it is possible to run consecutively? The same person from legal thing, because I was in the second year when this judgment has been passed by the sessions court, then only my professor and other thing academicians give me the clue idea that go and read section 57 of IPC, fraction of imprisonment for life. It says 1 life means 20 years, 2 life means 40 years, 3 life means 60 years. Yes, any person can run 20 or 40 or 60 inside the prison if it is to run consecutively. So everyone must need this clarity, need this clarification. So please be read the law in between the lines, in between the words. CRPC is an ocean. It is not something which comes to your control on a single day or a month or 6 months. No, it is not possible. It's an ocean. You have to swim yourself. It will observe you once you get into CRPC. So such a thing is that. So there are a lot of things when you're going for practice, and or if you're going to occupy the position of public prosecutors or going to occupy the position of judicial officers. So kindly keep in mind that at the end of the day, we are there to give justice to the person who is expecting something from our hands. So thank you so much for your patience, and thank you so much everyone for your patient observation. Thank you so much, sir, Vikash sir, for giving me this opportunity. And if any question, I'll just accused placed audio recording and transcription held between victim and accused proving accused innocence, but the victim filed application for removing recording as same while the rights of the price. So whether the fair trial of accused or right of the no, with respect to this accused placed audio recording and transcription which has happened between the victim and the accused when they were in a normal period, when they were in a very close or casual period. So we can take this for example, consensual relationship. I think today also there is a judgment which says that promise to marry and having sexual intercourse and fail to marry shall not constitute rape. So by the time, that's what sometimes if you want to invoke this, either voyeurism of IPC section 354C of IPC voyeurism, which means recording of this, providing, yes, I'm having the right to prove, and this cannot be challenged as the against the privacy. What would happen if the girl submits any photograph or videograph that happened between herself and the accused when they were in the normal course of time? So for protection, if it is being permitted, it is the hands of the court to decide whether to accept it or not, but it has to be within the in-camera proceedings for analyzing the same.
That was the only question, ma'am. And thank you for sharing your knowledge. And tomorrow, do connect with us on a fascinating topic at 6 p.m.
Sure,
do
sir.
connect with us on the social media platform of LinkedIn. Thank you, everyone. Stay safe, stay blessed. Thank you.
Thank you all. Thank you.